I know that at the stage of QLTS-MCT, which is a precursor of the SQE, we were not assessed on civil litigation or dispute resolution. It was assessed at the stage of OSCE or SQE2, which is very logical because I think it's quite hard to assess people via multiple
Right.
choice question in this particular area. But we will consider a few questions today. I don't think very complex. But we have students who currently prepare for the SQE2. And in the light of SQE2, which is very similar to OSCE, on which topics do you think they should focus for the SQE2 purposes?
It will be good for them to focus on time limits because I can think of all those issues which are related where you can get confused, like how you calculate the time limit to submit your particulars of claim and whether, and also in terms of like conduct questions whether you come across a particular document and whether you should disclose it or not, because those kind of questions is where they will test you in the MCT because there is no direct answer and it changes from situation to situation. So that's where, as we have seen from MCT in QLT, is there is no direct answer to the question. All the answers look very similar, but there is only one correct answer. So probably that's where they are going to judge you because it won't be like a fill in the blanks kind of question. So it's going to be more like in terms of the situation which is given, the question, the facts, and how you're going to apply the rule to it.
If you let me to add, I think it also depends on the kind of the assessment. When we are talking about advocacy, this is obviously different sort of interim applications. That is something which is more likely, or interim remedies that you may be asked to submit, and likely you will be able to handle a trial in 15 minutes, though.